to me like.
Guess who starts barking the second I hit go? As soon as I started, he starts in. It's crazy. Winston! I'm telling you, this dog does not bark all day. The second I go live, he starts barking. Yeah, go chomp on this. It's so crazy. So it's like 8:30, boom. He just starts... it's crazy. No, I haven't got boiled peanuts together. I've been working on the website. I know, what a shock, what a surprise. But I've been working on the website. So, and then I also had to make some candles, but that's why. So, because we got spring and summer coming, and now we got new labels and we got new designs, and I'm not happy with a couple of things. And I was like right in the middle of doing something. And then I'm like, oh my God, it's 8:35. So here we are. All right. How you guys doing today? I'm doing good. I kind of probably should get out of the house, but you ever like realize that every time you leave your house, you spend money? So you're not going to leave your house? That's where I'm at. So I figured, like, I think it's 2 days now I've been in. But if I'm in, then I can't spend money. So we're going to stay right here and finish everything I got to finish. So I hope everyone's doing well. And it is Fluffer's channel, I'm telling you. So what's up, Sly Angel and Sweet Carolyn and Carol, Rhonda, thank you for the super chat, guys. Squirrel, Denise, Rhonda, Crystal. Let's see. Boop, boop, boop. Let me start at the beginning. Carol, first one here. Usually Sassy's the first one here. Sly Angel, Denise, Crystal, Squirrel, Sweet Carolyn. I know some of you guys I'm repeating. I'm just kind of going down the list. What's up, Thunder? Hey, Rhonda. I saw Little Miss Sunshine was here, and thank you for the compliment. What's up, Spitfire, Cindy, Amber in the house, Salty. Who else? Did I miss anyone? I think I got everyone. Don't forget to hit that thumbs up. I have to remind you guys. Hit that thumbs upper. Yes. Always. Oopsie. totally forgot. All right. Hey, what's up, Johnny? Ugh. All right. I'm tired. So I heard the whole tragedy pimp thing went out and other people were talking about it. Did you guys know that that there's a channel who's not the creator, but one of the people on there is like the end all be all? I'm shocked. Totally shocked. They make all the decisions. Isn't that wonderful? All right. So let's get into this. I was minding my own business yesterday and I was scrolling through channels and I found that Brian Kohberger was in court. Okay. So I started listening and it was really, really interesting. And if you guys don't know what's going on, the big debate over it was, should his case be dragged out? I mean, to put it in layman's terms, that's what it is. Should it be dragged out? The defense, from what I understood, I didn't listen to the whole thing. We're going to listen to the whole thing now. But from what I understand, from what I heard yesterday, I should have listened to Emily Baker, but I didn't. From what I understand, the defense, of course, wants this all the way out until 2025. The prosecution is like, oh, hell no. We want this starting in this summer. Now, the interesting part, from what I found interesting, is the prosecution had some really good points. And one of the things they were saying is that, you know, if you do it in the summer or you do it before the summer, then you have people with graduation and you have all these things that people are not going to want to be able to get a hotel, or prices are going to be jacked up. So that's like the reason they want to do it in the summer. And he was saying that there's a lot of people that are going to come from out of town. And it was just really interesting. And I'm like, wow, this is really interesting to listen to. So here we are. And I'm going to play it. Hold on. I haven't had enough time. No, I haven't. I don't, to be honest with you, a lot of people disagree with me on this. I don't listen to a lot of other people that are going to talk about the same things I do, because I want to form my own opinion. I want to hear it for myself and not base anything on what someone else says. That's why I don't like listening to other people. It doesn't matter if they've had enough time, because it is a death penalty case and they're going to drag this out as much as possible. Hold on. Hey, Tanmo. All right. All right, so I'm gonna have to grab it from. Hold on. I'm gonna grab it from the person I was actually listening to it on. Hold on. It is cold. And it's like 45 here. It's still cold.
But in essence, what we're asking the court to do is to give us the court's blessing to take up the issue to the Idaho Supreme Court. I think the court has noted that it's certainly an interesting issue. The Idaho Supreme Court does have a rule that essentially lays out that this is to be done in very rare circumstances.
Okay, also, so if you don't know what's going on here, the defense team has decided that they're going to appeal the grand jury indictment. This is like so weird. So what they're appealing, from what I understand, what they're appealing is that they don't believe that Brian Kohberger should have been indicted by a grand jury. So they're writing the Supreme Court, or they filed a motion with the Supreme Court to, and if I'm wrong or Emily Baker said something different, let me know, because I mean, I'm not a lawyer. But that they filed a judgment, they filed with the Supreme Court to turn around and vacate the, vacate the grand jury indictment, which is really kind of dumb. It's smart, but it's dumb. And what I mean by that is it's smart in the sense that it's good that, you know, they want to prolong it and they want to, get a ruling, because that's what you do in these cases. However, that's going to prolong the case as long as the Supreme Court needs. So it could be like 2 years. And even if they vacate it, he's still on trial. So all it's doing is wasting time. And that's what they're fighting with. This whole hearing, from what I understand, is because the defense wants the motion thrown out, and everyone else is saying that's ridiculous because it's not going to stop him from going on trial. But that's what they're trying to say, that they just want to cut it and vacate it, and the Supreme Court will have a ruling if he should have been indicted or not. Honestly, it's the dumbest thing I ever heard. But that's like the premise of what this is about.
Important issues where people may disagree and that may make it more orderly in a particular case. Our argument is that for this case to exist, the indictment needs to be valid. If there's something wrong with the indictment, that's something that certainly should be addressed. We're also concerned about the fact that there is case law that says that if this case goes to trial, issues with the indictment may become essentially mooted by that and would never be answered. And there's relatively little in the way of case law in Idaho in the last 20, 30, 40 years. And so without permission to appeal, we may never get an answer on this. And certainly that's very important to Mr. Kohberger, because whether or not there's a valid indictment in this case is going to decide whether or not he sits here and whether or not a trial should occur, et cetera. One of the major issues is whether or not that's going to have an issue with the timeliness of this case. And my understanding is that's going to be the next argument that comes after this one. And so we believe if a trial is set out as far as we think it ought to be, that an appeal at this point won't disturb where we think a trial should occur in any case.
So my opinion on that is if they put it out to 2025, it gives them plenty of time for the Supreme Court to make their ruling. Personally, I think it's absolutely ludicrous, but that's what they're fighting for. That's what they're fighting on, the premise.
And in any matter, this isn't our attempt to achieve some delay. This is our attempt to make sure that our client is getting due process at every step in this case, and that nothing is being left, no stone left unturned. Thank you, Judge.
Thank you, Mr. Langston. Mr. Nye.
Thank you, Your Honor. I want to start with the rule that was just referenced. It's Idaho Appellate Rule 12, and it governs interlocutory appeals in The criteria in that rule set out two factors the court is supposed to consider. The first is whether or not there are substantial grounds for difference of opinion. And on this particular issue, as the court stated in its order, the standard of proof for grand juries in Idaho has been consistently probable cause for at least 3 decades. That doesn't sound like substantial grounds for a difference of opinion. And in fact, the defense conceded in their opening brief on this issue that, quote, the whole of modern jurisprudence on this issue is against this novel theory that they've raised. So they haven't met that first factor. The second one asks whether an immediate appeal may materially advance the orderly resolution of the litigation. And I have not yet seen in their briefing or heard in their argument any path forward for them in which winning this appeal materially advances this litigation. I think if we're all being honest with ourselves, a trial in this case is going to happen. And the question is when. And if we send this case up on appeal, even if the defendant wins, the law clearly allows for us to bring the case back. Even if the Idaho Supreme Court goes out on a limb and says, you're right, the standard of proof in a grand jury should be beyond a reasonable doubt, we could use a normal complaint and probable cause hearing in front of a judge. So it would be the same standard yet again, and we would go in a whole circle, basically resetting the case to be.
See, Colleen, I agree with you because they're fighting an appeal. I mean, they're fighting an argument based on what everything is. The grand jury indicted him on probable cause. Everything that the justice system is based on probable cause. So the prosecution is right. This is what I was like saying yesterday. The prosecution is 100% right in the fact that it's based on probable cause. So even if it gets thrown out, the police are still going to arrest him and a trial is still going to happen. So this whole thing is just a complete waste of time and a stall tactic. It's not an appeal that means anything.
Where we're at today. We need to get to a trial in this case. And that brings me to my final point.
I totally agree, sir.
There are secondary factors that the Idaho Supreme Court has looked to in addition to that rule, even when those first two factors are met, to decide, is this actually the case that we want to take an interlocutory appeal? And my read of those secondary factors is it's really asking, like, what is the effect of this appeal on the litigation and on the parties and those involved? And I would just like to point out to the courts, under the rules, this is Idaho Appellate Rule 13F, and it's talking about the stay upon permissive appeal. And it says in F sub 2 that the granting of a motion for permission to appeal under Rule 12 by the Supreme Court automatically stays the entire action or proceeding until the appeal is terminated. So at that point, there's no more discretion. It automatically this case hits the pause button. But more than that, Your Honor, it continues and says, and dear.
One thing I would like to know, though, why is Brian Kohberger in a suit? Brian Kohberger is a convicted criminal, somewhat convicted. He is arrested for an possible quadruple homicide. Why is he wearing a suit and not handcuffed? That's what I want to know. Why is he not a danger? Why is he sitting there looking like an attorney?
During that time, the district court or administrative agency shall have no power or authority over the action or proceeding.
But I will show you 30 different death penalty cases where the guy is shackled up. Someone that is not convicted, but someone that is charged with quadruple homicide are usually in handcuffs and orange. And you're right, there's no jury there yet. So why is he in a suit?
We're not just talking about a stay in the proceedings. We are talking about this court losing its power and authority over this case while the appeal makes its way through the appellate process. That is going to cause significant delay. As we're about to have an argument or a conversation at least about scheduling. And there is a lot that needs to be done before this trial happens. And this court will have no power to address those issues if this case is pending on appeal. Now, in full disclosure, there are some exceptions to that rule, but it's the exact same exceptions that apply to an appeal as of right after judgment. So it's things like you can change the sentence, you can sentence the defendant, you can change bail, things like that. But for discovery, we've had the genetic genealogy issue that's still out there. We're working and making progress on, but pause button on that, pause button on discovery, pause button on change of venue, pause button on motions about experts and who can say what. It would significantly delay this litigation, which brings me to my final point.
All right, just come to think of it. This school shooter, his parents, I know the mom's like on trial or something. They were in orange jumpsuits. They were handcuffed. They weren't charged yet. I mean, they weren't convicted yet.
Point, and that is, I don't want to lose sight of the fact of the seriousness of this case. We are talking about a quadruple homicide. Under Idaho's law, not only are those who were killed victims, but every single one of their immediate family members is a victim. And in this state, in Idaho, our victims have a constitutional right to a timely resolution of the litigation. We are already quite a ways out. And the idea that we would hit the pause button and take power away from this court because there is a interesting issue for the Idaho Supreme Court to address is not something that this court or any court should tolerate.
Agreed.
It's time for a trial, Your Honor. Thank you.
Absolutely time. Long overdue.
Mr. Logsdon?
By the way, the voice you hear in the background, it's Jewels of Thought, or now she's called allegedly innocent. I ran it from her because that's what I was watching yesterday.
Why?
Judge, once again, we believe this to be an important issue and one that is worth getting a glance, at least from a higher court, rather than being tucked away and forgotten in the maelstrom that is to come. As the state undoubtedly knows, trial won't put an end to this case. This case will go on for 28 years if they do actually achieve a conviction. So the idea that somehow we're running towards something and that's going to do anybody any good from their standpoint is, I think, false. What we're trying to do is make sure that the things that occur in this case are done correctly. And if you want to talk about how long things are going to take, get some stuff wrong and then see how long it all takes. We're asking that the court would give us permission to go and see if the Idaho Supreme Court would be willing to weigh in on this particular subject. Whether or not the case makes its way to trial at some point is, in our mind, just part of what the court has to look at, particularly in a case where the state's decided that it wants to try to kill someone. Thank you.
Excuse me.
Well,
Well, first of all, this is a reconsideration of the order
That he already
relating to dismissing the indictment, whether or not the standard for proof on a grand jury is probable cause or beyond reasonable doubt. I don't think we've done anything wrong about that. That decision was put out quite a while ago. It's rooted in well-settled law. And I think it was correct. Supreme Court, I guess, could turn that around, but that is doubtful in my opinion.
I think it was correct too, Judge.
We went through Idaho Constitution, statutes, case law, criminal laws, and really common sense. So I feel quite confident that that was a correct decision. So that established that it is well established that the standard of proof for indictment in the grand jury is probable cause, not beyond a reasonable doubt, which is the standard for trial. So putting that aside, now we get to this permission to appeal under Rule 12. So, excuse me, let me just get this in front of me. So the criteria for permission to appeal, this is in Rule 12 of the Idaho Appellate Rules. First of all, it's very, very rare in case law for such an appeal going to the Supreme Court.
That's where I got Supreme Court from, because I knew the judge said it, but it is weird. I have never seen somebody try to appeal a grand jury indictment unless they hope that it was going to get thrown out and then they weren't going to get anywhere. Like, there's no reason for them to appeal it. It is a complete waste of time. Complete waste of time.
Court does happen, but it is rare. And the court has established this criteria. And I'll just read this part of this.
Alyssa looks a little irritated.
The issue needs to involve a controlling question of law as to which there is substantial grounds for difference of opinion. Again, in my opinion, and based in all the law in Idaho that I've found, is that there's not a difference of opinion about what the standard for the grand jury is. So the defense is making that argument. I respect that. I don't agree with that, but that's where this is. I don't see a difference of opinion throughout the state about what the standard is for grand jury determining an indictment. But this also has a second component. And this is something that Mr. Nye really focused on, is which an immediate appeal from the order may materially advance the orderly resolution of the litigation. And I'm very concerned about delay. And I think that if we send this
right here, her right here, Elisa, she is Brian's attorney. I don't know who this one is yet. But this one is Brian's co-counsel. The one on the right.
to the Supreme Court, that it's going to add delay. Mr. Logston is correct. I mean, this is a complicated case. It could take a long time, longer than any of us want. But I think that would add additional delay. As I said, I'm already concerned about that. We're over a year. Could be another year. I'll just let you all know that. Now, even if the Supreme Court takes up this appeal, or I deny it, and I'm going to deny the permissive nature of this. If I deny it, the Supreme Court can still pick up the appeal. That's up to them. But they do look at what the district judge's opinion may have some bearing on that. I hope so. But they could still overturn the orders of this court denying the motions to dismiss the indictment. And they could dismiss the indictment. What would happen then? Okay, is this going to really materially advance the orderly resolution of the litigation? The state could just file it, refile it, as Mr. Knight said. So That's significantly more delay. So there's some other, actually, this is in a case law, Buttle versus Todd, where it's an old case, 1983, but the court also considers other factors, including the impact of the immediate appeal upon the parties, the effect of the delay of proceedings in the district court pending the appeal, the likelihood or possibility of second appeal after judgment is finally entered by the district court, and the case workload of the appellate courts. But it finishes with an appeal must be exceptional, seeking of that appeal. Because the Supreme Court doesn't broaden the appeals, which may be taken as a matter of right under Rule 11. So, in my opinion, I do not find that the criteria is satisfied for a permissive appeal. There's no controlling question of law where there is substantial grounds for difference of opinion. The law is settled as far as I'm concerned, and there's no difference that I'm aware of. I also do not see how the appeal could advance the case. To the contrary, it would stall the process when we really need to move forward. So I'm denying the permission for appeal, obviously denying the motion to reconsider. And with that, I think we are ready to go to setting a trial, or at least a schedule order. So anything else about this issue before we go to that? Ms. Taylor?
No, Your Honor, thank you.
Mr. Thompson?
No, sir.
Do you want to go first, Mr. Thompson, about the state's position on scheduling?
Yes, sir. I'd be happy to. And to start, Mr. Lodson said something that I think needs to be addressed. He makes the allegation the state is trying to kill someone here, and frankly, I find that offensive. What the state is trying to do is to enforce the law that our legislature has put in place. It says, in cases such as this, with facts like this, a jury is entitled to decide not only guilt, but potential felony. We are simply trying to fulfill our responsibilities under the law. To characterize it as the state is trying to kill someone, it's just simply appealing to raw emotion, and it has no place in this court. We would ask that that not be allowed any further. Now, as to the trial, Ms. Nyer already noted that we have a variety of competing interests here. We have certainly the defendant's right to a speedy trial, which he has waived at this point. There are also interests of the state itself, and I think even more importantly, the victims and the families of the victims in this case to a timely disposition of this case. Granted, this is a complicated case. It is a very serious case, and a lot of effort needs to rightly be put into it to make sure that the case is handled correctly. At the same time, we need to also balance the need to move forward in a constructive, productive fashion. When the state filed our motion asking for a scheduling order and trial date, which was a little bit over a month ago, we proposed the summer of this year. And at that time, at this time right now, we believe that we could be prepared for trial summer of this year. We realize defense has factors and considerations they want you, Your Honor, to take into account, and certainly we want to afford them that opportunity. I will say, though, that, and that we touched on this in our motion, in our request for the scheduling order, that given the nature of this case, if we are going to try this case effectively with minimal unnecessary harm or disruption to our community, it should be done during the summertime. And I say that because right across the street there is Moscow High School that shares parking all around the courthouse with everybody else who's going to have an interest in this case and being here. And we've already encountered the conflict between those interests. We can't sustain that for weeks and weeks on end. That's just not fair to the students. It's not fair to the school district. It's not fair to the media. It's not fair to anybody. The other factor is, as your honor knows, we have two universities, part of our community. And during the academic year, we have graduations. We have numerous sporting events and other university-related events that essentially consume every available hotel or motel room within miles.
He's so right about that.
This case is going to involve bringing in people from out of state, numerous witnesses from out of state who will have to be put up in lodge. And we would submit that that's going to be unnecessarily complicated if trial occurs while the universities are in session. So those are the considerations that we have, Your Honor. As I said, we filed this last month at that time, and as we stand here today, we believe that we could be ready for trial this summer. Thank you, sir.
Thank you, Mr. Thompson. Saylor?
Thank you. Your Honor, I received Mr. Thompson's motion for a scheduling order, and I had the opportunity to meet with him and talk with him and Ms. Jennings about that. So it is no surprise to the prosecution that we do not believe a summer of 2024 trial is realistic in any way. Understanding the state's concerns, if a trial were to happen in Latah County, we would suggest looking at summer of 2025. However, council and the court's aware that our intention is to file a motion for change of venue. That hasn't been filed yet because we're not ready to have that heard yet. There's work that has to be done to present to the court and council in support of that. So that's just for the court's information. Your Honor, that in the state's scheduling order, it asks the court for various things. And a lot of those we don't have disagreement with. We think they're appropriate. And in fact, they were things that were covered by the court in the court's original scheduling order. As the court and council recalls, last fall, we had not made the choice to waive speedy trial. And so the court did a scheduling order at that time. It wasn't but a few days later that we'd had enough time to discuss that. And Mr. Kohberger decided to waive his speedy trial, and the court vacated that order. So I'm familiar with what the court likes to put out there as far as a scheduling order, and I don't think there's a problem with that. I would want to inform the court that I do not believe this is a 6-week trial. I believe this is more like a 12 to 15 week trial. This is, as everybody said today, a very complicated case. And I want to talk a little bit about what drives both our request no sooner than summer of 2025. And I say that with fear, Your Honor. There are a lot of things that we have to still do. I want the court and council to know that we haven't sat around waiting for a scheduling conference to begin doing those things. We have been on this case and active and seeking discovery and reviewing discovery, meeting with experts and working the case since the day we were assigned this case. So with that said, there's still plenty to do. And I want to talk a little bit specifically about that. In a case where there is the potential for a death penalty, we're looking at 2 tracks of trial. We're looking at the innocence phase where there's tons of witnesses and a lot of things that happen. And if there is a guilty verdict, we immediately go to a sentencing phase. That's up to the jury what happens there, but both parties have to be ready to proceed forward. So we don't get the luxury of focusing on our case, the state's investigation, our own investigation solely. We focus on that. We are working on that, but we are required to begin our mitigation case. That's what it's called, the penalty case. We are to put on mitigation. We are guided by the ABA standards, American Bar Association standards in capital cases. That's what this is. A death penalty case is a capital case, and we're guided by those standards. And they tell us that as attorneys, we must investigate every aspect of the case in the innocence phase. We must meet with
I would hope that the ABA standards are for every case, not just death penalty cases. I found that weird that she made it sound like that if it's not a death penalty case, they don't have to follow the same rules. Yeah, you do.
with our client regularly, which we do. We must engage in experts and understand the issues that are coming, which we are. The American Bar Association guidelines in capital cases say we must hire a mitigator and there must be a mitigation investigation. We hired a mitigator, probably one of the very first people we contacted. And so that has been ongoing for 13 months almost as well. We have not been sitting back and waiting. Your Honor, in this case, the complexities are that there are special areas of focus. And when we get to trial, counsel for the state will put on experts to educate the jury on specific areas of focus, as will we. And it takes a while to get all of that done. In addition to that, as the court knows, everything is recorded. There's digital footprints all over the place. And so we have a lot of records that we have to go through. I know that the court has heard about 51 terabytes of information that we've received. And I want to tell you what that means.
I do not believe for 1 second that she has 51 terabytes of information. I just don't.
Massa found a statistic for me, and I want to tell you how much 51 terabytes of data is. And she found that. She was looking at Dropbox.com, and 51 terabytes of our discovery, to put it in perspective, 1 terabyte can hold 250,000 pictures. 1 terabyte, and we have 51 of those, or 500 hours of high definition video, and we just have 1 of those. So 500 hours times 51, or 6.5 million document pages, and that's equal to 1,300 filing cabinets. And we have 51 terabytes, not just 1. So that's a lot. There's specialized knowledge. There's a lot to go through in this case. We also have another player in the case, and that's the presence of the media. This is a case that has drawn a ton of attention from the media, and it continues to do so, and I don't think that's stopping anytime soon. The impact of that is that we have found that when we want to talk to witnesses, sometimes they don't want anything to do with us. Sometimes they're people that have already talked to the media too much, and so we shouldn't talk to them or bring them into the case. So that's just a complication. We're working through it. We're working around it. But that's something that the court has to be aware of. I want to let the court know that there are over 400 potential witnesses in the innocence phase alone. I personally and my team have talked to less than 10%, well, less than 10% of those witnesses. In the mitigation phase, our mitigation expert has been actively working the case. We've all been working alongside our mitigation expert. There are still well over 100 people left to try to contact and try to interview. And let me back up and explain what we do with mitigation. We are to learn Brian's life story. We are to go all the way back to before he was born and learn his life story. We have to be prepared to talk about that in different ways. But it's not just a life story. We're required to go 3 generations back on each side, mom and dad. The court can imagine that there are a lot of documents that must be collected and examined and reviewed so that we are aware of things that we would need to present to our jury if we ever got to that phase. We have had a lot of trouble collecting documents. Sometimes it takes a court order to get documents. Sometimes documents are missing. Sometimes they're very old and you have to piece things together. We're working through it, but I want the court to know it takes some time for that as well. There are records yet to be obtained that we need in both sides. There are still experts yet to be hired that we need to find an expert that has the right expertise and will work on the case with us. We do have several, we're working with them, but there are still more that need to be found. And then let's come back to the discovery. I want to talk about some of the difficulties with discovery, and I want.
What did Baker say about that? Did she agree that it's total bullshit? There's no way they have that many pictures. I just don't buy it.
Everybody to know that I am not disparaging the state when I say this. I'm describing a complication, a challenge, probably one that the state shares. In this case, we began asking for supplemental discovery in February of 2023. We had some initial discovery, and then we started looking at it and asking for other discovery. We are up to our 11th request for discovery, and there's, I think, 250 items total with subparts to that. The state will respond to us. They're not ignoring us. I'm not saying that at all. There's just a lot out there. But this is complicated because the discovery that we received, the materials, there's videos, there's interviews, there's police reports, there's photographs, 13,000 photographs that come in, and they are not indexed. So you get a discovery file and there's tons of sub files. And I believe this is the way the state's getting it too. And I believe this is complicated because we have multiple law enforcement entities that have been working on the case. And I believe they filter discovery through one of the entities and then it gets to the prosecutor. And I think they're hurrying as fast as they can to get the discovery to us. So I think they're giving it to us as they get it. But there's no indexing in it. So you must open each of those files and see what you have. And you might have police reports in sequence, and then you might not. And you might have photographs, but you don't know which officer took them. You can tell where they are, but you don't know which officer, and you don't know what day because the officers were in that residence multiple times. So that's complicated to try to match all of those things up. There are things that we've asked for that have taken, it's just taken a long time. The court knows we've had motions to compel and we've had some pretty lively debates about what certain things that we should have and certain things that they don't want us to have for other reasons. Those things take time as well. We don't have complete discovery. I don't think the state has complete discovery, but we definitely don't have complete discovery. I'll give you a couple of examples. There is a video that's a really important video, and we early on received some of it. And we are still waiting for the complete of it. The court would know from our 11th discovery request that there's still outstanding portions of that video that we need to have. And I think the state's working through it, trying to match up video and sound together for the completion, the full several days worth of video. But there's not even an estimated day when we'll get that. And that is critical for us to review and hear all of that. So that's an example, Your Honor, that is not us saying we just don't want to go to trial, we just want to drag our feet. That is us saying there are critical things that we don't have. I am very concerned about expert reports. We have a draft of one, the cast report. The court had ordered that we receive the cast report. It's a draft. I don't think the state has it. I don't think they're sitting back on it, but I don't have that yet. And there are completed materials all over the place like that we just don't have. Our team speaks with the prosecution team fairly regularly about these issues. We communicate by text and by email about things like this that are coming up. We've sat down and spoken with them. They're very open to talking to us, but this just isn't a closed deal. There has to be a deadline on discovery. There has to be a target date where that ends. And then there has to be time to make sure that we've read every piece of it, watched all the videos, looked at all of the photographs, and know where they came from. A few months from now is not a sufficient amount of time to do that. There is no possible way I can even read or watch everything I have now or react to things that are still coming in if we're to have a deadline in time for a summer of 2024 trial. There is no possible way that I would be effective in my investigation, in my presentation to a jury, if I don't have the state's expert materials ready to give to my experts and then get them a report to respond to. There is no way that I am effective assistance counsel if I haven't looked at every bit of discovery that's available. Recently, Your Honor, as recently as January 4th, we received discovery that contained over 9,000 tips that law enforcement had obtained. And we've had, this isn't a new issue, I think the court's heard about this before. We've had bits and pieces of tips and they've come in and we've reviewed them, but the 9,000 new ones we received January 4th, those were closed out in October of 2023. And I don't think the state sat on them. I think that's an example of the process that they close them out so they can give them to us. But they go through.
All right, just curious, why would they need the tips? If they're not the police, they're not going to go follow up on the tips. So what is the big deal? Maybe I'm missing something, but I don't see what the big deal is about 9,000 tips. They're not the police.
Other agencies before they get in the prosecutor's hands to give to us. I have to read every one of those 9,000 tips. There are things that matter to us in our innocence phase that have come up and been done, and I have to read them and appreciate them and react to them and see what's there. That's the duty I owe to Brian. That's his right for effective assistance of
Excuse me,
counsel
would
to
you
have me
like
do those
A
things.
savory snack?
Your
or
Honor,
a
summer
sweet
of
snack?
2024, it's impossible for us to do it. Our team constantly meets, we constantly work. We are on this. This is our priority. Brian's our priority, but we are not going to be ready. And
Oh, I know she's buying time, but I don't understand why. It's not like, even if he's convicted, they're not going to they're not going to kill him within like 30 years. So I don't know what the buying time is, unless they believe that they're going to put him to death within the next couple of years. But everyone knows death penalty cases, they drag out, because once you're convicted, then you have an appeal. I mean, it's at least 10 years of appeals before you can even think of being executed. So I don't get the big deal. I don't know why a year is going to make that much of a difference. He's not getting off. I mean, if they have a solid case, he's not getting off. No, 28 years till he gets killed. But I'm saying that, you're wrapped up in appeals for at least 10 years.
June 2024. Your Honor, I want to also talk about some of the other deadlines. One of the things in the state's motion for scheduling order had to do with the alibi defense. And as the court remembers, we had made some submissions and we needed more information before we could do anything more complete. We're still in that circumstance. But when the court vacated its scheduling order last fall, that was part of the scheduling order that was vacated. So the state asserts in its scheduling order that our time has expired, and that just can't be, because the court didn't carve that out and say, I'm going to vacate everything but this. So we'll need a new date, but I'd ask the court to be really mindful of the other information we need. We need the cast report. We need other information.
I think
of
Judge is
things
going to
that
need an
past
Adderall.
agents and other
He looks
specialists
like
with
he's
the
about to
FBI
go to
might
sleep.
have done with cell towers and records. And I don't have all of those yet. I have some. And the state has pointed me to places that they believe I have more that maybe I missed in the discovery, and I'll look at those. But I'm going to need some time to do that. I wanted to let the court know as well, because the court's going to be considering a scheduling deadline for 12B motions. I want us to have a clear picture before we have that deadline. And the clear picture that I'm concerned about is the state's pathway of how Brian Kohberger comes to their attention and is identified. I've read that PC affidavit over and over and over again, and I'm not sure. Over a year into this case and everything I've read, and I've spoken with our team, we're not sure how the state decides on Brian Kohberger. I know different pieces, but I don't know where they fit together. And the more work I do, the less I know about how they fit together. And that is critical for us to assess 12B motions. So while the court's doing deadlines for discovery, I need the court to have something with the 12B keyed on when I have full discovery. I also think it would be appropriate for the court to allow windows to file additional motions based on later disclosed materials too. I think we'll just keep getting materials until the court sets a deadline for it to be cut off. Not anybody's fault, just the magnitude of the case. And so I think that would be something appropriate for the court to set as well. I think that covers it.
Thank you. One more question. So
Sure.
I understand this. I mean, I'm aware of disclosures already. But do we need a whole nother year after this summer? I mean, can I help everybody by having tighter deadlines? to make
Yes,
things
it's a
happen
great idea,
faster
Doug.
So that we can get this trial sooner?
Not another year.
That's a tough question.
No.
If the state says you have everything and I believe they could say I have everything they have, but I know there's other things out there. I know it based on responses to discovery. If I had absolutely everything, all their experts' reports, I would still need a period of time to read and understand that. There's not a shortcut for the amount of time that it takes to go through everything. There's just not a shortcut for that. Having a deadline for discovery helps me. It just does. Having a deadline for expert disclosures, that absolutely helps me as well. I have the concerns of discovery that's not yet made available. I have the concerns of the time it takes to review all of the materials. And I have the concerns about the limitations we're finding with people being willing to talk to us, both for the innocence phase and the mitigation phase, should we ever get there. I have significant concerns. We're working on it. If you could say, everything's going to go according to plan, I'm going to give you these deadlines and all of the materials will be in the state's hands so they can give them to you. And the records you need will be given to you when you ask. And the witnesses that you need to speak with won't slam the door in your face. If you could tell me that, then I would say I could be ready by March of 2025.
Oh,
And that's
my
me saying I'm
heavens.
going to spend
Oh my
every
heavens.
possible hour on Mr. Kohberger's case, which I've been doing and which I'm willing to continue to do, and so is the rest of his team.
Wow.
But my problem is that's best case scenario if we don't run into problems and delays getting records or getting people to
This
talk
is
to
not
us.
right.
And if the next calls I make on the experts that I don't have yet secured, if they say yes and they're ready to go and have time to take it on, that's best case scenario. I'm nervous telling you I'll be ready by summer of 2025. I'm nervous telling you that.
You're nervous with 2025?
This is priority for everybody. And I want to be realistic about it. I don't want to set it more than once. I only want to have one trial, one time.
Totally,
So
Anna.
it doesn't come back. We can only predict the future so much. I only have so much power. So I'm relying on counsel deeply. So let's go to Mr. Thompson and see what you have to say about all this. Just getting things ready for trial.
Ms. Taylor is not understating the amount of work that's involved in this case, Judge. I think that's fair to say, and there's more information that continues to be developed. It's kind of like you ask one question, you get an answer, and that leads you to another question. I know that Ms. Taylor and her co-counsel and investigators are encountering that. We are trying to provide things as quickly as we can, and she's right. There are delays with the multiple agencies getting everything together. The tips, for example, were part of a nationwide tip line that needed to be completely shut down before we could get all the tips that were in it. And so that's why it took so long with these 9,000, I didn't count them, but there are thousands and thousands of tips, most of which are out there, but you're right, all of which need to be looked at to see if they have any potential relevance to the case. As I indicated to the court, if we cannot have a trial this summer, then I would say the earliest would be the summer of next year. For the reasons that I've described to the court about the practicalities of carrying on a trial that duration with the high school, with the universities. We need to be realistic about being sure that we can get our witnesses here. We'll have something to put them, and there won't be undue interruptions in the community that could cause issues with the community's perception of the trial proceedings. I'm not quite sure what else I can offer
You're making some kind of argument that changing venue, but
Yeah.
I know we're not arguing about that.
And, I don't think that's gonna change anything, Judge.
Oh,
When
really?
this case has national, if not international attention.
Okay, but there are
This
parking
spring, I was
lots,
at
hotel rooms,
Association
and
of
other
Council of
places.
Counties board meeting in McCall, and there was more news every morning from Boise on this case than we see up here. Every doggone morning.
What?
I have
the
people, friends in this
hell?
community who have traveled to Mexico, and they say, people here were from Moscow, and immediately they want to talk about this case.
What does
It's
that
not Moscow,
matter?
it's not Latah County. It's everywhere. So I don't think that a change of venue is going to solve any of these problems.
It's going to solve your
And the state's
your
position on
parking lot
venue
problem.
is that the case should be held here. It's a Latah County case. We believe that we can select an appropriate panel of jurors from Latah County. We have the tools to work with that we've discussed with Your Honor. In fact, we already have a fairly comprehensive draft juror questionnaire to send out so that the court and counsel can assess the level of knowledge and the feelings of the potential jury pool. But we think that we at least owe Latah County, the people of Latah County, the attempt to seat a jury here first.
You don't
And
have
not
a
just rely on
parking
there's been a lot
lot,
of
is what
publicity.
you said.
There's been a lot of publicity everywhere. The only place I've heard that there wasn't publicity is in Lewis County. Somebody was talking to a court down there, and they happened to mention Kohberger and said, "What are you talking about?" So if we want to change venue, I guess we could go to Nez Perce.
Kind of small.
It's kind of small. Lodgings aren't very good as far as a lot of
That's
lodging.
your complaint about
But I think
Moscow is
that's-
lodging and parking.
That is a
space.
practical observation on this case. It's not just here. It's not
That's
just
so
Moscow. It's not just
dumb.
Latah County.
This is so, wow.
Thank you, Mr. Thompson.
Wow.
You're saying,
Like,
looking at
a park
this
and ride.
realistically and the amount of information, evidence, non-evidence, that's, you might be looking at summer of 2025?
I'm saying that could be where we end up, Judge.
No,
I am
Judge.
still concerned about the
No,
victims
just
and their
change
families. I
venue
mean, they
to a
have
bigger
suffered
town.
for well over a year now with a lot of uncertainty. And that's painful. It's an everyday reminder.
Can you imagine though, being one of the families, one of the murdered families, and your trial is not going to start because there's no parking? Like, are you fucking kidding me? Can you imagine?
Reminder. And they need some certainty and they need some closure in a timely fashion. But we know we also have to make sure, as Your Honor just said a few minutes ago, that we only do this case once.
This is the biggest stall tactics, and both are doing it. It's like watching T-ball when you think you're going to watch the damn World Series. His complaint was about the high school is across the street and the parking lot serves both locations. Remember? So it's got to be in the summer so that school is out. And what are we going to do if there's a football game for the college? Then we're not going to have a hotel room. His complaints, the prosecutor's complaints, were about space, facilities. So then they're saying, the judge says, oh, okay, so really what we're talking about is change of venue. We need to go to a bigger place that can accommodate all these people. And now he is saying, the prosecutor himself is saying, no, we could totally handle it. We just need to do it in the summer of 2025. I wonder if he's calculated this. Ann Taylor just said it was going to take, what'd she say, 12, 14 weeks? Is that what she said? Last time I checked, that's longer than the summer vacation in a school.
That doesn't come back on appeal, that doesn't come back for subsequent things saying that somebody made a mistake. We want to do it right. And the factors are in front of Your Honor. I think that you're certainly in a good position to make the best decision.
It's a decision that pulls me in two different
I appreciate that, Judge.
Judge, you can build a damn
Um,
parking lot in 3 months.
I don't
Wow.
want to set it right now. I mean, I'd like to get a little closer with Discovery and see if we can have that more quickly. I'd like to speed it up if it's possible.
It is possible. Be a man. Take
I'd really
control.
like to do this sooner than later.
Come on,
maybe-
Judge. Be firm.
In March, 2025, which
No.
that would be a reach.
It's ridiculous
just
to go to
wanna
2025.
percolate
This
a
is
little bit. I
ridiculous.
know everybody probably here, including council, want a direct certain date. But when you're talking about a date so long in the future, potentially, maybe we can get to a point where we can move it more quickly. I'm not gonna just let it hang for too long. but
Oh my God. Oh my goodness.
it's really hard for me right now to set something in 2025.
I
Even
feel
though that might be
like
just the
we're listening
reality.
to John Pryor on steroids.
And I know that there's lots of other issues to be addressed. I know there are going to be a lot of motions. Going to be a lot of motions about the death penalty as well. So it's realizing to think that we have to have a case so far in the future.
Take control of
That's-
this, Judge.
What is the right thing for everything to do it correctly? Maybe we only have to do it one time. Because we don't want to do this twice. We don't want to do this 3 times. Because no matter what happens, okay, if he's convicted, it's going to be appeal. And that's also a challenge. So my heart goes out to the victims. I can't even imagine the pain.
The woman talking is Jules of Thought, or allegedly innocent. So I don't understand though. Now they both want, so I didn't hear this yesterday, but now they both want it summer of 25. Now I'm totally confused.
The grief, because you can't really go forward.
That's exactly
If you
correct,
like-
Judge.
It's hanging over your head. So, sorry.
No, don't. Oh my God. Oh.
Let's see. All right, so I'm gonna contemplate a little bit.
Wow. Attorney, a middle getting on a out of town something. I think the group's working together. After what we just saw with the prosecution and with Ann Taylor, it looked like to me that they had.
So that was it. There's no more after that. Was that it? There's no more. It's a total stall tactic. Totally. Oh, okay, Monica. That makes sense. Because I'm like, what the hell? So that's what I heard. Hey, Hybrid. That's what I heard yesterday. And I was like, wow. Just wow. I thought it was absolutely ridiculous that she claims that she has 51 terabytes. No, I'm not buying that. I'm just not. I don't believe that you could have 51 terabytes of information Like, what documents do you have? What info do you have that the rest of the world doesn't? I just think it's an awful lot. So another thing that I want to touch briefly on, hold on. I really want to know why he's not in handcuffs. Hang on a second. All right. Did you guys hear about this though? Jennifer Crumbley trial. There was like a big debate. Heated argument erupted in court yesterday after Jennifer Crumbley's defense attorney said, "I'm going to kill myself" during the trial, sparkling backlash from prosecutors who said it's disrespectful to the victims and their families. Have you guys heard about this? Talk about being frustrated. Jeez. Because it doesn't matter. Every single criminal is in handcuffs. Show me a trial of a criminal that's not in handcuffs before they go to trial. Pre-sentencing, when there's no jury. He is not. His hands are free. His feet are free. He walks in, he walks out. It doesn't matter if he's factually innocent. Every single person that is in pre-trial like that is in handcuffs. Or they're in shackles, or they're in, I'll prove it. I'll pull it up. Hold on. They're not showing him in pre-sentencing though. I'm talking pre-sentencing. Here you go. Lori Vallow is in orange. Whenever you see people in court, they're in orange. They're in handcuffs. He is accused of a quadruple homicide. But you don't think you should keep him handcuffed? Okay. Don't cry when he jumps over and knocks the judge right in the fucking head like the other one, though. Hold on. Huh. Quadruple homicide? They're not supposed to be in street clothes till the trial. You wear a suit for the jury. You don't wear a suit for the judge. Judge don't give a shit. Turtle Boy was handcuffed. Thank you.
I know the court does not like objections through in the midst of testimony. There is an officer that is going to be testifying. I have numerous objections to many of his exhibits that are proposed.
Who is it?
Stoya, I'm not sure I'm saying Stoya.
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 Okay.
And Your Honor, I just want to make the record clear. I received all of the materials in this case in over 30 discovery, sets of discovery given to me. Okay, I went through all the discovery obviously as it came in. I did not get the exhibits that were being used in this trial. They weren't identified. I didn't get them until after day one of jury selection. So I have done my best.
Wait a minute, there's a scheduling order in this case.
Judge, all of the exhibits come from the discovery. This digital evidence was turned over 2 years ago.
Well, she doesn't say she didn't have the evidence.
I'm not saying I didn't have the evidence. I'm saying that it wasn't identified until after day one of jury selection. So I just want the court to know I'm doing my best to object and to handle the evidence.
I don't envy your job, Ms. Smith, at all. I don't. It's a lot. I don't envy their.
Correct me if I'm wrong. From anyone that follows this case, wasn't she like hired? Aren't they like top criminals? I mean, top tier attorneys, or did she then go with a public defender? Because I remember in the beginning, they had hired some top tier attorneys. So I don't know if this is the same person or if she ended up now doing public defenders. Oh, they're now public. Yeah, they didn't in the beginning. They had top tier attorneys.
Their job either. It's sad. It's voluminous. I know it's very difficult. So tell me what you're asking.
Okay, so the issue is I have numerous objections to exhibits they intend to admit. I know the court does not like to have objections, but
No, that's not true. I didn't want to rule on I didn't want a surprise ruling on a motion this morning. I would have been more prepared and also would have told the jury if I were. I don't like the jury waiting for us. There's nothing wrong with objecting to an exhibit as someone attempts to introduce it.
Judge, we handed over the exhibit list with very precise.
She's not that young. She just has nice hair.
Pages, and we did that. We weren't required to at a certain time, but we did that. I think the first day we were here, Ms. Smith told Mr. Keese she would be providing her exhibit list to us that night. We did not receive it. So I'm not sure what the purpose of providing an exhibit list is if she's not going to actually go through it and say, these are the ones I want to object to. These are the ones I have an issue with, and we can talk about it. And then the court knows that there's something to argue about before we bring the jury in.
Your Honor.
Okay, well, I think that's what she's trying to tell me now.
I'm trying to tell you that now, and also every time we've been off the record, I've had conversations with Mr. Keese during this next witness. I'm not objecting to any of these exhibits. Mr. Keese, I plan to object to a lot of the photos with Stoic.
Yeah, if she represented Nassar, she's a top attorney. I mean, he had enough money to cover everybody. I mean, he had enough money to cover any attorney.
I haven't talked to Ms. McDonald, but that doesn't mean I haven't communicated to them when I have objections.
Okay.
That is just misleading, and I'm tired of it.
Okay.
I'm saying, I just want to know what the objections are so we don't have it. It'd be great if we could know that before.
How long are we going to be here? Because the jury's waiting for her to be brought down. So I'm pushing a lot of the deputies here.
We have a few more things. We're just asking, let's hear what the objections are about the exhibits.
I'm going to release the jury.
Okay.
For one thing, these walls are not great with that. And the deputies are, I'm going to owe the deputies doing it for the rest of my career. Yeah, let's let the jury go, okay? Can we let the jury go?
Your Honor, I have just a suggestion. I think there's gonna be evidentiary issues with some of these exhibits. So I'm wondering if maybe the jury should come back at 9:30 on Monday or
Okay,
something.
Ashley, can you tell the jury to come back at 9? Tell the jury to come back at 9, okay? All
Just
right,
so
we're
we
gonna
have
do
time. I know the court
Okay.
doesn't wanna waste their time.
Well, you do, one exhibit at a time. There's nothing wrong with that. People do that in trials all the time. But obviously, if we can streamline it in any way and not do all the juries here and have them not moving in and out since there's 17 of them, that would be good. I guess I don't know who the first witness is going to be on Monday. There's an Officer Stoyak who is with what department?
Sheriff's Office, Judge. We don't know if he'll be first witness.
No, and she's let us know she has some issues with some of those pictures,
Okay.
and we'll figure, if she just tells us which ones, then we'll decide if we want to stipulate. If not, then we can handle it before the jury's.
Oh, I can already tell you they're not gonna stipulate. I can tell you we're gonna need time on the record, like,
Okay, well, I think.
I'm not sure how to respond to that.
No, I think that the prosecutor was saying that you might stipulate to the admission of some of them, right? And you have a right to object to something being admitted, right?
right.
Okay, so I'm looking at the list,
There's many photos from inside the home
okay?
that I believe are contrary to the orders this court has already given. Like the messiness, there are irrelevant photos. There are photos of the stairway to the basement, completely irrelevant to this case.
Why do we care about the stairway in the basement?
That's
Judge, we,
why-
counsel and I, she indicated she was gonna create a list of which exhibit numbers, they're numbered already, they're numbered,
Right.
and just tell us which ones she's object to. We'll review that. If we agree, then we'll strike them from our exhibit list.
Okay,
We
and
talked
we're
about
here
this.
to talk about it at 8:30 on Monday morning, because maybe we can.
We could get a list before that, then we might not have to argue about it.
Your Honor, part of the problem is they won't tell me who they're calling. They gave me the exhibits after the trial, the list of exhibits after the trial started. There's one of me. I have co-counsel that has not been with me this whole ride. And so I'm doing the best I can, and I have to sleep at night. And I've been here for 8 hours a day this whole
We've all
week.
been here. I've spent many hours on this case, and so
I
as a
know.
prosecution, I know there's only one of you, but you're also retained counsel,
I
right?
understand that, but I need, and this weekend, thankfully, I'll have time. I will get them the list of objections,
Okay.
but
all right,
when
that helps.
when I don't even know which witnesses are being called the next day.
Okay, I don't know of a rule.
Honestly, the judge's calmness would drive me fucking insane. Insane.
That obligates them to do that.
Okay.
And Judge, you asked us to communicate.
And you did.
We
You
did.
Good.
She, she knew last,
Wagorowski.
Wagorowski was good. I mean, we did tell
Okay,
her.
all right. So over the weekend, hopefully they're gonna do the same. Over the weekend, will you tell them the witnesses you're gonna call Monday? Will you do that?
We tell her every single day when she
No,
asks.
they
These are
tell
our
me
lists.
at
But we do, if I can,
9:30 at night.
if I can just finish.
Okay,
If I
I'm
could
sure
just
you
finish.
don't know yet.
We already changed that today. I mean,
Okay.
that does change, but
What are you gonna tell her about?
When we can confirm childcare for our witnesses
Okay.
and confirm, we have one person with COVID right now, but one person out of the state. We're rearranging witnesses in real time.
Okay. What objection, non-responsive? Can you tell her Sunday by noon?
I hope to have those answers by then, and
Sure.
I'll communicate as soon as I have the answers.
I don't think they're obligated to do that. On the other hand, it is a courtesy, and it is something that helps the trial move quicker.
I think it should just be fair.
It
For
would
instance,
also,
we
Oh,
don't
no,
have.
we don't want this to be.
We don't have an exhibit list from the defense. She said she'd provide it the same time we did that night. We don't have it. We
I
just, we
didn't
just
say
want
I
to be
was
treated.
provided that night, and
Okay.
I didn't know what exhibits I would need until I saw your list, and I haven't had time this week because we've been in court or.
Okay, all right. Yeah, I'm obligated to be fair to both sides, right? This exhibit list, regardless of when you got it, to me has been very helpful. It's descriptive of
Thank you.
where and when, and because, some of the,
You can
some
thank
of them.
Natalie
overlap.
for that.
I-
Some of
Is this a jury trial or a judge trial? Because if it's a jury trial, I don't understand why the judge has spent so many hours on it. She doesn't make the decision. But if it's a judge, so it is a jury. So why is the judge spending tons of hours on the case?
Your Honor, I don't disagree, but also some of mine don't match what's been put up on the screen. Like it's not as simple and as clear cut. I have this weekend, which is going to give me time.
Okay, good. Good. Yeah, okay. They're gonna communicate with you, and if you tell them which ones you object to, I don't know if I've seen some of these. Some of these are in the house, some of them might be relevant, some of them might not be.
I don't think we've seen any of that.
What's that?
I don't think you've seen any of them.
Judge, listen, if she just make a list, we'll be happy to review it with her, so you don't have to please.
Okay, so you're gonna be here at 8:30 on Monday morning. We'll talk about as many exhibits as possible. In general, they can go question and answer and all that, but if we can agree on some beforehand, I'm just going to pray that by Monday morning, there are no issues. Can I do that? Can I go to the river in Egypt?
Judge, regarding exhibit 423, counsel indicated that there are certain messages she wants redacted. Counsel can indicate those, what messages they are. We'll be happy to redact them before the actual exhibits turned over to the jury.
Thank you. I think that it was based on messages that were already excluded via previous motions.
I don't recall any specific messages previously excluded by this court from exhibit 423.
There were
Counsel's-
topics.
hang on.
It would be
Counsel's-
hard for me to compare this right now to my orders.
Right, that's why if counsel's requesting for it to be redacted, I just ask counsel, tell us what to be redacted so we can do it.
Okay.
Your Honor, then I need them to send me this proposed exhibit.
You have it, you already have it.
423.
You had it in January of 22.
Okay.
Messages between.
Wait a second.
Wait, you guys wanted, someone said they want all the.
It's
you-
the
you
Facebook
said
messages.
I'm
You want all the
trying-
Instagram messages between the defendants and that's what you said.
Facebook.
And that's,
Facebook.
Your Honor, that's totally fine. All we have to do is make them compliant with the other orders of the court that have already excluded evidence.
Okay, that's fine.
Yeah,
You're
I'll
the one who asked for
reject
it to come in.
But I'm asking them to give me the original file of 423, because I don't have 423, and I will go through and redact it. I'll do it tonight.
Judge,
Okay, but
they
you
have
can't
it.
just- You can't just reject it. They have to know.
Well,
what they're
I-
requesting to be.
Judge,
I'll mark it off what
the
needs
truth,
to be
the
redacted.
truth should matter. She has 423. It's the entire Facebook message string between Jennifer Crumbley and James Crumbley. It's the thing that she piles up. She has that string. So
The court would like we can produce a proof of service first thing Monday morning.
No, and I'm not saying I do have it in the evidence. I don't have it. They're talking about it as if they've given me a 423. They haven't. It's buried in the stacks of evidence.
Okay.
That's fine. I'll dig it out. I will go through it tonight. I will let them know what I want redacted.
Okay.
All I
You can
want
send them,
is
yeah.
redacted.
we provided a digital
It's a
copy.
thumb drive.
I don't understand.
There's a thumb drive that has 423.
Yeah.
Yeah, they handed it to me today while we've been in court for 8 hours.
Okay,
So
Okay, but you're the one who asked for it to be admitted, right? You're the one who asked for it to be admitted. So, which I'm happy to do. If everybody agrees. So, all right.
Wait,
Everybody-
you have just a couple more things here.
Uh-oh, there comes the cover. What else?
Just one thing I think is important. I asked this court to instruct counsel to show the appropriate decorum in this particular case. The jokes indicating I'm going to kill myself in a joking manner. I'm drinking 5 bottles of wine.
It's just,
You
there
have-
are parents
That's
who
my
had their children murdered in this courtroom, and we are the people who communicate with them after we leave
I
here.
said something about wine because I was looking at her exhibit and it was teetering. And I was trying to nicely suggest that I would like you.
But making a joke about killing yourself in this courtroom at this time, I understand.
I
I'm sure it
didn't mean
wasn't-
it like that. I'm sorry. I am so sorry. I did
You
not
can
mean it
stop
like that.
yelling that I don't
I
want
did
to
not mean it like that, and they know I didn't mean it like that.
We're responding to literally just sitting here, the amount of messages we get from victims in the community. And I just think just to be at an abundance of respect and caution, if we could just not say things like that. I'm not accusing anyone of any malice or any bad intent. I'm just asking that we just not engage in that, because this is hard enough for the people who are sitting here now and who will be sitting here next
I
week.
understand. It's very hard.
Your Honor, I am not joking around about anything.
Okay, I think it was a slip of the tongue. It was a slip of the tongue, right? Emotions are running high. We also, a lot of people are saying Ethan needs to be the shooter,
But Your Honor, I do want to make a point. I'm not making an objection because my emotions are running high. In fact, I'm not having an emotional response here. I am simply asking that we be respectful to victims. That's it.
Your Honor, I am being respectful. So that is implying I'm being disrespectful. Me saying I'm gonna kill myself, I didn't mean in any way to offend
I know you didn't.
these
I know
families.
you didn't. It was a slip on the tongue. She's just.
It was absolutely not related to them.
I know.
This shooting is awful. It's the prosecution that's parading all of this up here and putting.
Parading?
through
The
this.
shooting is the result of the defendant's gross negligence. That is the case.
They are the ones putting the
Okay,
victims
everybody
through
needs-
re-seeing all of
everybody
this
needs-
over and
Oh,
over
Your
and
Honor,
over.
Whoa, everybody needs to go home. Everybody needs to go home.
That-
All right?
I understand that we're not putting victims through anything and I'm sorry, but that just because everybody's disagreeing doesn't mean everyone is inappropriate. We aren't putting victims through everything. We're prosecuting our case and we're trying to do it in the most efficient way
And she's
possible.
defending her case. I think that was a slip of the tongue. Everybody needs to take a deep breath and go home. Everybody go home. I'm going home.
All right.
Okay. That looks like an interesting case that I mean, not an interesting case. I know the case, but an interesting trial, since I normally don't like trials. But you guys can say what you want. I'm not even going to say my opinion. I'm going to keep my mouth shut because it'll only get me in trouble. So I'm going to keep my mouth shut. But is the trial that interesting? It hasn't been boring. Yeah, I should start watching it. I'm going to start watching it Monday. Is she over her head? Well, I think that's because there's no case law for it. It's a precedence case, which is wild. I mean, it really sets a precedence. But do I agree with the precedence? No. All right, I said it. I don't think Crumbley should be charged. I don't. I know a lot of people disagree with me, but I think it's ludicrous. What their son did is on their son. There's lots of mentally ill people that don't shoot up schools because their parents are assholes or their parents are give them a gun. There's plenty of people out there like that and they're mentally ill and they don't go shoot up schools. Put the responsibility where it belongs. So that's my opinion. And I know a lot of people disagree with me and I'm okay with that. You lock your cupboards, they wouldn't bother. A lot of people don't. Depending on where you live, a lot of people don't lock up their guns. Yeah, they're going to sell each other out. I can't believe how much she's aged in jail, though. She's aged a lot. Yeah, but Spitfire, a lot. I mean, their situation, a lot of people do. Sea Thunder, I don't agree. It's a good point, sweet one. That's a good point. See, here's the thing with that, though, Sly Angel. We don't know his history. We don't know if he was a hypochondriac. We don't know if he lied to his parents a lot. We don't know if his parents told him that stuff and it was never turned out to be true. We don't know. That's what I'm saying, Colleen, and that I disagree with. And yes, they should have taken him home that day. But it also comes down to your own kid. There are things Dayton tells me, I'm like, yeah, okay. Because I know he lies. I know my own kid. So he'll tell me stuff and I'll roll my eyes. I mean, not like he hears voices and stuff, but I don't know. I don't believe they're horrible parents. Okay. We'll give them that. They're bad parents. But I don't think that what he did is their fault. And if that's the case, then he should be in a mental institution. If you're going to blame somebody else for his actions, then he should not be locked up. He should be in a mental institution. Because the only way that they're responsible is if he's not responsible. If you're going to say that he's responsible, then the parents are not responsible. If you're going to say he's not responsible, then the parents are responsible. There's a lot of red flags screaming at people. And they don't do anything. But they don't go kill someone. A lot of parents choose to ignore. He owned what he did. He's responsible. But do you know what I'm saying? Like, you can't say someone's responsible and then blame someone else too. If his parents are responsible, then he can't take responsibility. So that makes his parents responsible. You know what I mean? It's like you can't have it both ways. He can't be responsible and then have his parents responsible too. His parents weren't there. They didn't do anything. They were shitty parents, but there's lots of shitty parents out there that aren't in prison. Oh, absolutely. I'd feel different if he was 8 or 10. Because then they'd be responsible. 8 or 10, you don't know right from. I mean, you do, but you don't. So that's just how I feel. But lots of parents buy their kids guns. Lots. And the kids don't go shooting up things. There's lots of shitty fucking parents out there that buy their kids guns and they don't go shoot up a school. Yeah, absolutely be charged with bad parenting. But if every single parent was held responsible for the actions of their children, half of America would be in jail. And that's a fact. The parents' guns were put away. And mom probably didn't take him seriously. If Sage told me she was going to blow up a school, I'd laugh my ass off. I'd say, yeah, okay, Sage. I wouldn't take it seriously. Parents thought he would off himself and all their trouble would be solved. Maybe you might be right. Based clear on the law, I didn't understand how they could charge them. But after learning the facts, I'm hoping they're convicted. It's not a logically consistent position to be in, but so be it. They deserve charges of being bad parents. But there's a lot of children out there who come from bad parents, who have guns bought for them, and they run the streets. Is that a fact that they said that? They were counting on a self-harm situation? I don't know if I believe that, unless I heard that from their mouths. But there is no law to back it up, Janice. That's the problem. As of right now, there's no law that makes parents responsible. Mom didn't go home until her husband was home. I think she was afraid of her own son. Probably was. And maybe that's why she didn't take him seriously. You never know. One never knows. She's aged a lot. I can't believe how much she's aged. Crazy. All right, I'm going to shut down though. Get back to my work. And that's it. All right. Thank you guys for coming in and watching it with me. I like having people to talk to. She doesn't. No, she does though. She looks terrible. A child seeing demons needs help, not guns. True, if they believed him. They may not have believed him. They may have thought he was full of shit. Which happens often. A lot of times your kid will tell you something and you're like, yeah, whatever. But I'm going to start following this kid. I'm going to stream it on Monday. I'm going to start streaming it. So you guys can watch the trial here. As long as I can find it outside of Law and Crime. But it should be pretty easy to find. They wouldn't, maybe they were doing some secret plot. I don't know. I just say that you can't be responsible. All three of them can't be responsible. Someone's got to be responsible. You got your chat working. All right. I will see you beautiful people tomorrow. And maybe I'll do some research and we'll talk more about this case. I'm not sure. I have videos on this case from a while ago, though, but let's get back into it. All right. I will see you beautiful people tomorrow. Have a wonderful day. Peace.